Hello friends, in the series on the income tax cases, today we will discuss a very important issue about the defective and invalid returns. The importance of this topic becomes more important from the fact that this issue has been now settled by the Honorable Supreme Court. This issue came before the Supreme Court in the case of Mangalam publication versus CIT, and this case has been reported in ITR 461 at page number 159, and the date of the judgment is 23rd January 2024. This case becomes the center of attention of various professionals because this case was circulated in the various WhatsApp groups and in various mails. So the logic for discussing this case becomes more convincing. In the present case, the assessment of the assessee was completed for the assessment year 88, 89 to 93, 94 under section 143 subsection 3. The documents were not available with the assessee because these documents were seized by the department. In the search proceedings, the assessee requested from the department to give these documents to the assessee so that he can file the return of income, but the department did not cooperate with the assessee, so the assessee has to file the returns without accompanying profit and loss account and balance sheet. The assessments were completed. After completing the assessment, the assessing officer came to know from the bank of the assessee that the assessee has submitted some balance sheet into the bank for the purpose of availing some loan facilities, and the learned assessing officer compared the balance sheet which was obtained from the bank, and that balance sheet was relating to year 89. The learned assessing officer compared this balance sheet of the year 1989 with the balance sheet of 1993, and he came to know that there is a lot of difference between the capital of the partners in these two balance sheets. So the learned assessing officer took the difference of this capital and added it into the income of the assessee. When this matter was before the CIT Appeal, the CIT Appeal said that in the present case, the balance sheet is not reliable, and according to the CIT Appeal, there was no other evidence other than this balance sheet obtained from the bank. The CIT Appeal was of the opinion that there was no false declaration by the assessee during the original assessments. So the assessment under section 147 cannot be done now because this is a clear-cut case of change of opinion, because the assessment of the assessee has already been completed under section 143 subsection 3. And more importantly, it was the finding of the Commissioner Appeals that returns were not treated defective by the learned assessing officer at that time. CIT Appeal gave the relief to the assessee, but this matter was carried by the department in further appeals. Department also gets some relief, but ultimately this matter came to the Supreme Court, and the Supreme Court said that in the present case the assessment has already been completed under section 143 subsection 3, and there is no allegation on the assessee that the assessee has not disclosed true and full disclosure before the first assessment. So it is a clear-cut case of change of opinion. And more importantly, the Supreme Court said that a return may be defective, but it cannot be invalid return. It was the point of the Supreme Court that whenever the assessing officer comes to know that some return is defective on the ground that it is not accompanied by balance sheet or profit and loss account or for some any other reason, then it is the burden duty of the learned AO that he should intimate these defects to the assessee and get it cleared from the assessee. If he does not do so, then he loses the right to treat the return as invalid. So the contention of the assessing officer that this return is invalid and it cannot be relied upon does not hold good in the present case, And the Supreme Court said that in the present case, the assessee has disclosed all the material facts which were necessary for completing the assessment. So now reopening the case of the assessee just because on the basis that some balance sheet has been obtained from the bank without any further evidence cannot be done. At the end of this video, once again I am repeating the name of the case. The name of the case is Mangalam Publications versus Commissioner of Income Tax, and this case has been reported in 461 ITR at page number 159, and the date of the judgment is 23rd January 2024. Thank you, friends.